Good evening and welcome to the December 11th, 2025 meeting of the Yorktown Zoning Board of Appeals. My name is John Meisterich. I chair the board. With me tonight are Tony Tripodi, Anthony Altamari, Bill Gregory, Bob Fahey, Building Inspector Steve Fraietta on our left side here, and Nisreen Khoury, our legal assistant who works in the building office. Our first order of business tonight is to approve the minutes from our last meeting, which was in October. I'll make a motion to approve October's minutes. Do I have a second?
Second.
All in favor?
Aye.
Yeah, I'm also going to spend a little time talking about our next meeting, so if you're here under new business or have a public hearing, you will be coming back, most likely. So our next meeting is on January 22nd, 2026, here in the boardroom at 6:30 p.m. If we mark you down for a site visit, that will be done on January 17th, 2026, which is a Saturday morning. Usually before 12 or 1 o'clock, we are done. So we start south end of town and work northwards. If you have a hearing open, you will have to send notification mailings to your neighbors, and those mailings must be postmarked between December 29th and January 7th. If they do not meet those dates, we cannot open your hearing. So you'll also have to post a sign on your property, provide a picture of that sign with an affidavit stating that you posted your sign. With the mailings, you use certificate of mailing, which is cheaper than certified mailing, and you provide a copy of the notice to your neighbors. So again, certificate of mailing, it's much, much cheaper. Okay, so we will move on to our new business, Yorktown Community School. Is anyone here on that one? Okay. Maybe I'll come back to that because I do have a few questions on this. Charnis. This is an application for renewal of a special permit to allow storage of a commercial vehicle in a residential zoning district.
How many years have we been doing this?
This is my 10th time doing this.
I remember
Since
the first time
1999.
we did it.
I've been on the board since 2012, and I remember going to your house. So.
You love this community service. I like it.
So I assume it's basically the same as it's been for
Yeah,
the
nothing's
150
really
years
changed,
that we
yeah.
just said? Okay. So I will make a motion to refer this to building. I'll set it down for a site visit on January 17th and a public hearing on January 22nd. Do I have a second?
Second.
All in favor?
Aye.
Okay. So we'll probably be just doing more or less a drive-by on you, so you don't have to sit there
Okay,
necessarily.
yeah, right. You can just look at it.
Unless you want to.
No, that's
Because we're a
okay.
lot of fun.
I mean, if you got the, if you got the coffee and the donuts,
I'll have
Okay.
some hot cider for
Yeah.
you.
that's even better. I like that. I like it.
So if we don't see you on the 17th, we'll see you on the 22nd.
Right. Right, okay.
Next
All right,
year,
very good. Thank you.
2026.
Okay.
Thank you.
Bye-bye. Take it.
You still have to do the notifications and all that with the yeah. Okay, Diaz. This is an application to construct an addition on a garage on a corner lot that requires a side yard equal to a front yard setback of 24.52, where 30 feet is required. And no one here. This is 3408 Fenimore Ave. Okay, so I will just, you're not on Diaz, yeah. I will make a motion to refer this to the building department, set it down for a site visit on January 17th and a public hearing on January 22nd. Do I have a second?
Second.
All in favor?
Aye.
Okay. 380 Downing Drive, LLC. Are you Yorktown Community School?
No, I'm Diaz's architect.
Oh, okay.
Oh,
I'm sorry. Well, you got your public hearing on the 17th, unless you have a question for us.
Oh, no, I thought I had to be here today.
I'm sorry, yeah.
These are just the prelims. The main bout is next month.
So the applicant does have to send out the notifications as I was instructing with the dates and make sure they're aware of that.
I'll check with them to make sure that's done.
Okay,
All right,
thank you. Okay, 380 Downing Drive LLC. This is an application, it's 380 Downing Drive. Application for a building permit to construct a loading dock with a rear setback of 13.2 feet where 40 feet is required per the town zoning code. So I will make a motion to refer this to building, set it down for a site visit.
Planning.
Okay, I will additionally refer this to planning.
Can I make a comment on that? This is in front of the planning board already.
Yeah,
Okay,
Okay, so they'll send us a memo on
Okay,
that, in that
just so
case.
you're aware.
Okay. So building, planning, a site visit on January 17th and a public hearing on January 22nd. Do I have a second?
Second.
All in favor?
I,
Aye.
Okay. Yorktown Community School. Okay, well, this is 247 Veterans Road. This is an application for a special use permit for a daycare facility that requires a special use permit for section 300-53 of the town zoning code. The premises are in an R120 zone. Yeah, so Steve, I know that this school exists, so do you have any background as to why they're applying for a new special permit rather than a renewal?
Because it's a school in general. It's stated a school. Now they're gonna be bringing in daycare kids to stay there, so they need a,
so in other words,
special permit.
in other words, they're changing their operations.
Correct,
Okay.
you know.
Where's 247?
Is this YCNS? No.
What's the nearest?
It's right across from the
It's
park.
now like near the VFWs.
Yeah,
right?
yeah.
Yeah, right next to the,
Okay.
Planning, right?
Fire marshal building.
Okay. So I will make a motion to refer this to planning, the fire marshal,
The building
and the
inspector.
building inspector, and set it down for a site visit on January 17th and open a public hearing on January 22nd. Do I have a second?
Second.
All in favor?
Aye.
Okay. So we will now move on to our adjourned agenda. That is items that we had in hearings last month, and we have them come up. Yeah. So Nunez. This is an application at 3240 Hollywood Street for a special use permit for renewal of an accessory apartment, although it's actually a new
It's a new
accessory
application. If I,
that requires a special permit. So can you just state your name for the record?
Jose Binona, sir.
Okay. So, the last we were here, there was a little confusion with this renewal versus a new, and I then set it down for a site visit.
Yes, sir.
And then, Nizreen tells me that you were there and we didn't show up.
We were there on Saturday.
I'm sorry, sir.
It's okay. So I actually was not available on Saturday, but the rest of the board here tells me that they were.
We
They
were
did
there
try
on
to
Saturday. We
go
banged
see
the
the house.
doorbell and knocked on the door.
Oh, you could just call me. I was waiting for you guys.
We expected
Yeah.
to see you there. We didn't know we had to call you.
No.
We don't do that.
Oh, I'm
you're
sorry.
there and you wait for us. Yeah,
My
we
mistake. I
didn't know
thought
to
you
call
actually you were gonna knock and they're like, okay, inviting them for a coffee or something.
We don't usually have the phone number, but.
Oh, I'm sorry for
It's
that.
okay. I mean,
I sent you guys an email like I'm still here 4 o'clock in the afternoon and
Okay, I'm sorry that you waited and this confusion occurred, but we should probably pull the file anyway on this. See if there's a memo from the building inspector.
There is.
that was a while ago, right?
Thank you. So I have a memo from Steve Frayetta, who is sitting right there, October 20th, 2025. This is an application for a new special permit for an accessory apartment per 300-38 of the zoning code. The property is in R110 district. I inspected this property on October 20th and found an existing apartment to be legalized with no occupants residing at this time. The applicant has filed a building permit application and will require a certificate of occupancy. I have no objections to granting the special permit. So within the file, there's also a plan that's up on the board there.
Yes, sir.
So basically it's like the first floor of the house,
Yes, sir.
more or less. I wouldn't call it, it's a walkout basement, basically,
Yes,
I
sir.
guess. Yeah. So one question I'll have for the board is how, do you want to go visit before we approve this?
I think the building department has made an inspection and has indicated that it meets all the requirements,
It does.
so I don't think that we
I did a
need to.
takeoff. I know the plan that's being shown isn't exactly.
So we'll just take this guy's word for it.
I think so.
Well, this
I think-
and the plan.
I did a takeoff, I did a literal takeoff on it,
I-
and it
I
meets all
think
the
we can do
requirements,
that.
the
I think we can do that. I
40%,
think we can
and it's really only 434 square feet. It's
Yeah.
not a very big apartment.
It's 430, because
Yeah,
that was
which-
one thing,
Yeah,
it doesn't
which is,
say it on here.
I mean, if you were doing the 40% rule too, you can have an apartment about 550
Right.
square feet. So
Okay, that's good information, so
he's
40%
good to go all the way around with it.
would be 550. I'm writing this wrong on this plan, but someone in the future will see this and say, wow. Okay, so we're legal in terms of all the dimensions and the areas. The parking, how do you feel about the parking? There's 4 spots apparently, but it's a little tight
It's a little
looking to
tight.
me.
Little tight, but
Hollywood
he-
Street's a
Yeah.
little tight.
No. He's got the parking, it's a little tight.
Yeah, a little tight.
Yeah,
Any other comments from the board?
You know, over there, you can't park, there's no street parking over there this time of year.
That's why he needs the 4. He's gotta have
Maybe up to 4 spots,
4
yeah.
spots.
Yeah.
How many bedrooms are upstairs in your?
I mean, when I bought the house, there were 3, so 3 still. you
Yeah.
know, and
And you live upstairs?
no, sir, I live downstairs.
Downstairs.
I rent upstairs.
Okay.
When I got divorced, I just moved
And
downstairs.
how many people in the household, in the whole building? How many? would you say?
Right now, they only have 1 baby.
And it's just 1 car or 2 cars?
1 car
1 car and you're 1 car.
and 1 car. Yeah, 2 cars.
I mean, the parking becomes an issue if, next time you come before us.
I have plans. I
yeah.
have plans to enlarge. That's basically that.
Because if your neighbors come and tell us that you're parking all over their street,
That-
and making a nuisance, that's really.
No,
where
I
we
understand. I currently
would be a
quite
risk
understand.
for probably the next approval. So does anyone in the audience have any comments on this application? Okay, so I will make a motion to grant the application for a special use permit for a new accessory apartment at 3240 Hollywood Street, with the stipulation that the construction be in accordance with the plans that have been submitted, the apartment layout in accordance with the plans that are submitted. Do I have a second?
How many years?
For a period of
Yeah.
3 years. Do I have a second?
Second.
All in favor?
Aye.
Okay. So 3 years. If, we'll see you again,
Oh, sir.
and hopefully there'll be no issues and you'll be good to go.
No problem, sir.
Thank you.
very much. Should I do anything else besides that? Just
It's all with the building
To
department
follow up
now.
with the building department.
thank you. Thank you very much. Have a nice day.
Thank you.
Okay, Pervisi? That's, this is a continuing application for a building permit to construct a Tier 2 battery storage system that requires a use variance. Tier 2 battery storage systems are non-permitted use per section 300-81.5 of the town zoning code. The address of the property is 3666 Old Yorktown Road. Good evening, and state your name, please, for the record.
Good evening. Thank you, Mr. Chairman and members of the board. Robert Gaudioso with the law firm of Snyder and Snyder on behalf of the applicant.
So obviously you've been here a few times, and I think, as I recall, we left it as one of the things to ask you to submit was minutes from White Plains, because you were aware of a situation that they had a use variance for a battery storage. And I did see that that's in the file there.
That's correct. We submitted that. They did apply the public utility standard there and grant the use variance under a similar circumstance as this application and this code. We also submitted the approval resolution from Tarrytown, which I think we discussed briefly. In that case, Tarrytown had adopted a code, and they issued a special use permit for a battery energy storage system very similar to this one in Tarrytown. So we submitted that resolution just, as a way of, information for the board.
Okay.
We did a few other things too, if I may.
Sure.
Because just to tie up a few ends that we had discussed, there was a question about the zoning district. It's a split lot. So as we mentioned, most of the facilities on the front of the lot, which is the commercial portion of the lot, the C-2 Commercial Hamlet Center. The back of the lot, which is actually undeveloped, is the residential portion of the lot. And there's no residence going in that direction. That direction goes up more towards, where the gas station is and things of that nature. So actually the residential portion is the undeveloped part. We also confirmed that we're outside the floodplain. I think we've talked about that a few different times. As you may know, we're in front of the planning board. We haven't been processing because we're here, but we were in the planning board for almost a year. We did relocate the facility previously outside the floodplain. We also elevated the facility above the floodplain. And we submitted a letter from the property owners, signed, saying a couple things. Number one, they've never seen flooding in this area, for whatever that's worth. They also confirmed there is no daycare center on the property, and they would be agreeable to a condition of approval that there would be no daycare center ever while the facility's in operation, and they'd be willing to, file something and record it to that extent. But they did submit the letter, and both owners signed. We also noted that there was the new fire code, which could be in effect, but definitely will be in effect by the time the facility goes forward, hopefully. And that starts on January 1st. And the facility has been designed to meet that new fire code, and things along those lines include the fire detection system. We already submitted the hazard mitigation analysis, the fire department training plans, the third-party fire inspections we've committed to. So basically everything that's in the new code that's coming online, this facility will comply with that code. And as you may recall, we had the chief with us last time. He's here again tonight in case you had any specific fire safety issues. Again, we think that's probably more appropriate for the planning board, but I think it was worth having that discussion because there was some questions, and we did fully respond to the county. If you recall, the county planning department did recommend approval of the use variance and talked about the importance of battery energy storage. So those were the additional things that I think we submitted as kind of a tie-up to our discussion at the last meeting.
Okay. Just a question on White Plains, so one of the things that kind of in my mind with this is the residential character of where the site is and the residential use of the lot. So was White Plains, it's a very different area, obviously, than Yorktown, but was that like an industrial, commercial
So
zone? Or?
interestingly enough, it was technically an I zone, but there were residences on both sides of the property. It was a very small piece of property, and I think the residences I want to say to the south were about 28 feet away, and to the north were even less than that. So actually there were two residences that were next to it, and initially the fire department, the building department had concerns about that, and then after reviewing the hazard mitigation analysis by ESRG, who different applicant but same fire safety expert, then the board ultimately approved it, even with those residences directly adjoining. In New York City, these facilities throughout the city, and correct me if I'm wrong, I think the setback there in most cases is 10 feet. So that has not been an issue.
Mm-hmm. So I'm going to open it up for public comments. Does anyone have any questions really right
Not
now
at
for
this
the
point.
applicant?
Who's responsible for the facilities located on the property owner's property?
Correct.
But who maintains the facility? Is
Right.
it the homeowner's responsibility?
No, absolutely not. So the developer leases the property and maintains all the responsibility. They'll be in charge of providing the insurance certificates, any of the removal bonds, the maintenance, the operation of the facility, 100% the developer, not the property owner.
That's what I thought, but I
Yep.
wanted to hear it said.
No, that's very important.
Okay, any public comments on this application? You just, when you get up here, just state your name for the record, please.
Sure. My name is William Briggs. and I'm from Sherbrooke.
Okay.
So Jim comments on this. In the September 11th meeting, Chairman, you stated one of the most important issues with this application is whether or not it meets the public utility variance standard to allow for this non-permitted use. So I think that's the key thing for this board to discuss. One of the things that was discussed in that first September meeting was one of the main case studies on this was Con Edison versus Hoffman to justify the utility use variance. So I just wanted to go back to that for a second just so we can kind of see kind of where this standard came from. But on that one, in 1978, Con Edison wanted to change a cooling system at Indian Point, and they wanted to put a 565-foot cooling tower up that was required for the new cooling and environmental laws because they had originally a cooling system that went out into the river. So they couldn't do that anymore. They needed to do this to meet the new standard. The village of Buchanan, where Hoffman was the head of the ZBA, they shot it down because their laws didn't allow for anything higher than a 40-foot cooling tower. And they also had issues with discharge of vapor and various concerns. Ultimately, it went to the New York Court of Appeals. New York Court of Appeals ruled in favor of Con Edison on that. And they basically set up this idea that standard zoning law versus utilities, a traditional unnecessary hardship, which is normally what you need for use variance, isn't applicable, provided that the public necessity standard is met. So public utility seeking a variance must show the modification is a public necessity required to provide safe and adequate service, and there are compelling reasons to make the modification more feasible than alternative power sources. So in this case, the zoning board failed to take into account the social and economic impact of closing Indian Point, which would have been the case had they not gotten this approval, okay? So with that in mind, and I know you've gotten a lot of documentation on this, voluminous documentation through the applicant's representative. As far as I can see, and from everything I've read in the notes and the minutes, the applicant has failed to establish they are actually a public utility. The land is privately owned by the Previsi family, which is not a utility, and the company that's leasing the property, Rick Energy, is not a utility either. As taken from their own website, Rick Energy Group is a privately held renewable energy developer. So they are a third-party company that works with utilities and sells power to the utilities during periods of high demand. If the zoning board approves this variance under this loose interpretation of what is defined as a utility, they are opening up the floodgates to any number of other interested parties that may want to build such battery stations, which goes directly against the ban that the town just put in. In addition to not actually being a public utility, the applicant has proved the standard, as outlined in the Hoffman case, and the representative, Mr. Guardioso, himself quoted in the September meeting. The utility must show the modification is a public necessity and that it is required to render safe and adequate service, and that there are compelling reasons, economic or otherwise, which make it more feasible to modify or build than to use alternative sources. The applicant has failed to show how this facility is a public necessity required to provide adequate service. In the Hoffman case, Indian Point would have needed to been shut down if they hadn't fixed the cooling towers, right? In this case, there's no direct correlation to necessity from this facility. The town is not currently suffering from rolling blackouts or brownouts. No one's power will be directly affected without this facility. The argument made that because the system plugs into Con Edison's larger grid and Con Edison can use the additional power does not make it a utility, and it does not entitle it to the same rights and of a standalone true public utility, and so it doesn't meet the utility standard. So that goes on to that, talking about the actual variance. And then I wanted to talk a little bit about this property specifically. I'm uniquely qualified to speak about this property because I worked on this property for 10 years when it was Peekskill Nursery. So for anybody in the town that may not know, this was a pretty historical thing. That Peekskill Nursery was there from 1946 to 2013. Mail order ground cover nursery, supplied Pachysandra and other ground covers all over the country, all through the mail. You know, I enjoyed working there. Very, very familiar with the property. So, as others have stated in the other hearings here, I can personally attest, I was there multiple times, that this property regularly floods. The Shrub Oak Brook, which runs alongside this property, carries all the waterfall from Lake Osceola, the entire JV Mall parking lot, as well as the Lynx Golf Course. As a result, during bad storms, this property will flood up to 3 feet, has been seen in this work building. So, right there where the driveway kind of wraps around, that gets it's been up to 3 feet. There was a line on the wall in there. We put Hurricane Floyd, 99, up to here. And then in subsequent flooding, it's gotten that. And I actually, as a matter of fact, I'll show them to you right now. I have some photos here over the years of the flooding. So here, if you want to pass these around. You can't even see the driveways or the access. It's completely flooded out, several feet of water. And it was kind of discounted in the conversation earlier that, if there's a flood, the odds of a fire or the odds of that are infinitesimally small. These are considerations that have to be made. If you're going to have a weather event, typically that's when you would have a surge in power. That's when you would have a transformer that blows up. That's when you would have these kind of issues. And there's not going to be any way to access that facility. Even if the facility itself is elevated on a platform, there's no way to get to it. There's no way to get to it from the other side, and there's no way to get to it in the front. The only way to get to it is from that completely flooded out road, which is a serious consideration on this. The other concern I had with this one is that, speaking to the general character of the property, it has a residence on it presently. There's an in-ground swimming pool right next to this industrial installation, so I really don't think it fits with the character of the property. There's a walking trail directly behind this, approximately right here. So I want to say it's about 15 feet away from the battery station. I don't feel like that was adequately addressed as to the proximity to the public, where they're going to be walking there in case there's an event of some kind. And this stream here goes directly into, ultimately, Peekskill Hollow Brook and then into the Hudson. So if there was any event where they had to use any retardants or anything like that, I would be concerned about getting into the watershed. So that's another concern. The Gomer Court Battery Station, which has been used as a point of comparison in this installation, it's not really a fair comparison. It's own country commercial. It's an industrial lot. There's I actually was just there this week. There's a body shop. There is a small residence almost attached to the body shop, but behind it is a big open parking lot. There's only a very small stream that runs behind it, and the stream is approximately 25 feet below the installation because it's in a hollow, and then they put the installation above. This installation, even if you were to put it up on a platform, is not going to be that much higher than where the water level is going to go, and it certainly isn't going to address the flooding on that roadway, which even if you raised it, literally the roadway runs right alongside that the Shrubbuck Brook. And then, just a quick reminder for folks that have been watching this along, but the memos that basically every department in the town, building department said no on establishing precedent and the access to the facility in a flood zone, which I concur with. Planning board said in a memo that it would be hazardous in the event of a fire, potentially with smoke and flames going on the Taconic 132. Town board says no to the project to direct impacts to traffic if there was an emergency and potential health hazards from such sites in the event of emergency, which is one of the reasons why the town voted to ban this in the first place, because there's some unknowns regarding if the thing catches fire with polyvinyl chloride and other chemicals being emitted. Even if it's a sealed container, if it goes out of control, these are concerns that have to be addressed. And then to sum up here, I must mention in researching for this meeting, I was disturbed to confirm that, in fact, there is a nursery school being ran out of this house on this premises for at least the past year. As indicated on Google, you can go on your phone right now, go to Google Maps, and you will see that it is advertised as Child Care of Shrubbuck. And I actually have some screenshots here, and it's all on Facebook. There's reviews, people going there. They basically renovated the basement of the house and made it into a daycare. This was completely glossed over by the applicant's representative, who said the owner would agree not to run a daycare on the property if this variance approved. However, the issue now is there currently is one there, regardless of what's being said here, with no state licenses and certainly not the required special use permit for the town, which requires, in addition to a license for such a facility, site visits to make sure the property's been safely outfitted for children. Regardless of how this turns out, I would respectfully ask that maybe this gets looked into by the zoning violation officer in the town. And I'm just going to give this to you all.
Okay.
And that was my comment, so I do appreciate your time here tonight.
So, yeah, regarding these pictures, I would like to find a way to put them into the record, but I can see they're your personal
Yeah,
property.
if you want to scan them in, I could
Yeah.
come back and get them if you'd prefer. I probably have some more photos too at home. Those I just got rid of those quick, for the meeting. But
So,
If you got more, definitely get more.
yeah, I have to
could do that
go
at
through the
meeting.
archives because I mean,
Well-
routinely would flood, and anyone that's lived in this town a long time remembers that this place would constantly flood, and I feel like we're discounting the fact that while that may be elevated, there's no way to get to it in the event of an emergency, and I think that's a real concern here.
Nazreen, do you think you could take these and make a
Yes,
scan
scan them,
or a copy and put them into the record, the file, and then work with this individual to return his property to him? Hopefully, we're okay with that. Okay. Any other comments from the audience? That was very,
Thank you.
Thank you.
Thank you.
Thank you. Okay, so let's let the applicant up to maybe make some counterpoints to, just going to leave these here for a moment so we don't lose them.
Sure, I'm going to try and work backwards. As far as the daycare center, you have a letter from the owners of the property that there is no daycare center right now. It's not being operated as a daycare center. It's neither here nor there. The point is that they've also committed that there will be no daycare center if and when this facility is operational. So I think we've addressed that. As far as the alleged flooding in this part, as you noticed, he pointed to the spot on the plans that had nothing to do with the facility. The facility is outside of the floodplain. The existing access drive is there. It's the house and the pool of the property owner that has entered into the lease with Rick Energy to have the site on their property, so they don't have any concerns about that. As far as secondary access, we also had addressed that in a prior filing where we indicated that if there were an event, there is nothing to do during the event. The fire department comes and they make sure that the event doesn't, and this is an extremely rare situation, and I want to stress that because we've put that in evidence in the record. We've put the documentation in to show how extremely rare it is, has been, and more so even now, despite the fact that there's such an increase in battery energy storage development, the amount of incidents have substantially reduced, specifically because of the change in technology which is being proposed here. But in the event, in the unlikely chance of an event, there's nothing to access. There's nothing to do. In fact, as part of the training, it's to train the fire department not to put any type of retardant or water on the facility. It's to allow the facility to go out on its own. It's to monitor the surrounding area. Nevertheless, we put in a prior filing that could be accessed from the front of the property. If there's a need for an additional drive, if the planning board thought that was necessary, we can certainly discuss that with them. So we believe we've actually established it. As far as the trail, I have a document here from Rick Energy, which includes photographs and a discussion with the property owner. The trail is just simply not used, and it's not maintained.
I have that already here.
So we have
Is that
photographs.
like a state or county trail, though, or is it
Town
just?
trail.
It's when you see the photograph of it, you'll see.
It's the
Well, I can see if it's.
iconic. You'll see where the bridge goes, the Veterans Bridge.
yeah.
That's part of the trail.
Yeah, it's an unimproved dirt path, essentially. And when you see the photographs, you can see what I mean. But we previously addressed this.
Thank you.
I also want to point out, there's no impact to the trail. The trail's not on the property. It's adjacent to the Taconic Parkway. Moreover, we've proposed a very robust and dense landscaping plan between the trail, the Taconic, and the property, even more so than what's already there. So there's no impact to the trail.
Will there be any fencing around the
Absolutely. Yeah, there'll be fencing around the facility itself.
Electrified and all that.
No, but there'll be a security fence, obviously, and the facility is monitored 24/7. So
Do you know how much space is between the property line and the Taconic State Parkway?
it is on the plans. If you give me a moment.
It's like,
What does it say right here?
that's 15-yard setback of the building.
Yeah, just to be clear, the facility does meet all required setbacks. You have a number by any chance?
Well, speaking of setbacks, I guess I'm curious how anyone would interpret that, because the question I have is this considered an accessory structure or main structure?
So to answer your question, it's 72.5 feet.
That's from the building, I see.
That's from the fence line.
I could probably do some math.
So that's from the cabinet, I should say.
And 31, yeah, so it's about 40 feet of
Yeah,
that
we-
trail.
I can say it unequivocally, we meet all the setback requirements. We meet any setback requirement in the building code, we meet any setback requirement in the New York State Fire and Building Code, and we meet any setback under the zoning code. So there's no specific setback that we do not meet.
Well, so I don't have like a plan in front of me, but it's this, it gets into, in my mind, that this is a residential property. And is this is this an accessory building in the rear yard? Is that what you're saying? Because
No,
10
it's a-
feet
it- it's
side
a-
yard setback.
We're
is a
seeking,
rear
no,
yard
we're
setback?
seeking a use variance, so it would be its own use.
Right.
And it's in that area, it's in the, I believe, the C2 district, and then the R1 120. But it's its own use, it's its own standalone use.
Well, I understand that, but setbacks in a residential district are actually defined by the placement of other buildings on the property. So we have a side yard, a rear yard, a front yard, and to say it meets the setbacks, we'd have to understand what is this and what yard is it in? So that may not be your area of expertise, because.
Well, I can say this, that we made a request, and we have a determination from the building department, which is the arbiter of this issue. Not us, not the zoning board, not until it gets appealed to the zoning board. So at this stage, the determination of the building department was we needed a use variance. There was no other area variance called out by the building department. So at this stage, this application's for a use variance and a use variance only. And I think that's the proper procedure.
I have a question with regard to, in the event that the battery storage unit catches on fire, there's nothing you can do but let it burn out. How long does it take for that to burn out?
So the thing here is that the Tesla Megapack 2 XL technology that's being proposed for this is the newest technology. So as part of the technology is everything is compartmentalized. So that way there should not be spread. That's the whole design. So it's designed that if there is some type of situation, which again is a very rare event, it would depend on whether it did spread or didn't spread. It would depend on the amount of time.
How many megapacks are going to be in
So
the unit?
it's a total of 5 megawatts spread out over 5 different standalone. I don't want to say containers because each one is then compartmentalized into smaller containers. So if you look on the site plan and if you look on the diagram that we submitted, and we also submitted the actual specification sheet for the Tesla materials, it's broken into 5 different spots. And then each of those are broken down, and then inside of each of that is broken down into different cells. So that's the
One
whole
of
point.
them breaks out in fire. Does that
The idea is that
necessarily-
it's contained in that compartment.
Which would be 1/5, let's just say for.
No, it would be less than that, because and then in each of the 5, then it's broken down into cabinets, and then it's broken down there into cells.
Okay.
And
When
there's,
it burns, what is put out into the atmosphere?
we asked that question.
One of you want to handle this one? You want to talk about this? And we did submit a full report that does address all this, and it's nothing different than a typical fire.
It was one with 400 pages.
Correct. So I think that it's a very important point. We'll let the chief speak to it, but you have to act on evidence that's in the record. So a lot of people say a lot of things. A lot of people say they saw something on the internet. That's not evidence in the record that you can rely on. But we did submit the evidence in the record that the chief will speak to right now.
Okay, thank you.
Good evening. Dan Murray, Energy Safety Response Group. Yeah, so as far as fires go, the way this Tesla Megapack 2XL system is designed, it has to comply with NFPA 855 standards for stationary energy storage, which is, if you're familiar with the National Fire Protection Agency, those are standards that are used in pretty much everything, whether it's construction, it's big with the fire service, and the boards. I sat in on some of the 855 meetings when they were coming up with the recommendations. And it's a lot of firefighters, industry people all sit on it. It also has to conform to the Underwriters Laboratory 9540 standard and the 9540A testing, which is something that our company actually does. What that consists of is destructive testing of these battery systems at the cell level. So like a battery cell, so one of these systems that looks basically like a Connex container has like thousands of these cells in them. They look like slightly bigger AA batteries. So they do the destructive testing at that level. They put the cells together into modules. So each container has several of these modules. They do the destructive testing at the modular level, and then they do the destructive testing at the full unit level. When they do this testing, it wasn't my company that tested the Megapack 2XL. They're so hard to get them to go into, we can drive a couple different cells within one unit into thermal runaway. We're able to do that by overheating them. But to have them propagate from cell to cell, which is where you run into trouble, it's very difficult to do. And as he was just saying, it's a very contained. The box itself, the cabinet, is very contained and sealed, and then it's compartmentalized. So it's designed to not burn. So as far as you spoke of gases, when an individual cell, and that's generally how when these things do burn, and they do burn, like everything, when all the safety systems fail. I believe in 2025 there's been, and not just Megapack, but all the battery energy systems, storage systems in the country, there's been 5 year to date in the United States. So it's a pretty unusual event. But if it does actually start off-gassing, and usually when it goes into thermal runaway, it starts off-gassing because each cell contains an electrolyte, which when it heats up to a certain temperature, we call it thermal runaway. So that cell is heating faster than it can cool, and it starts to run away. The way the system's designed is there's a battery management system monitoring every single cell in the system. So if there's any abnormal voltage or temperature event in that cell, the battery management system is going to shut down the system before it ignites. And this is very advanced stuff. Each module has its own BMS, which monitors each cell, and then that entire unit has its own BMS that monitors all the modules. And this is all remotely monitored from Tesla and also from a remote monitoring station through the developer. And it's all done. It shuts down both automatically and it can be shut down remotely. In the event that it starts off-gassing, that cell will start to release flammable and toxic gases. The main flammable gases being hydrogen and carbon monoxide. There's some other things like some propane, ethylene, propene. And the way this Tesla system's designed, it has a sparker system. So they're essentially spark plugs within the container that are constantly going, even when they're on the back of a truck and they're delivering us to the site. The batteries within the system are running these sparkers. So they're constantly going. So if there were to be a cell that starts off gassing, the concept that Tesla came up with is the sparker is going to ignite those gases before it can reach an explosive level. So it'll basically just flash burn off, and that should be the end of it. What they also have built into it is it's a deflagration panel on the top. So if it got to the point where there were several cells off gassing, which would be very unusual because you really need a fire to start propagating from cell to cell, and it built up to an explosive level somehow, the explosion would go vertically through these deflagration panels. They're like weak panels in the roof of the container. So it won't, and that was learned by the industry because there was a fire in Nevada and it blew the doors off and injured a firefighter, several firefighters. So the industry kind of, and that was an old system where the people would walk into the container. That nobody's making those anymore. So those are your main gases. Now, if it ignites and now you have a fire, worst case scenario, which can happen, where the entire container is burning, the products of combustion are essentially the same, or at least extremely similar to what you're going to find in a house fire or a commercial building fire or a car fire. It's plastics, it's metals, steel, aluminum, all the plastics that are involved, the wiring, the batteries themselves, that electrolyte, that's, that is the firefighter's main concern. If it's on fire, the electrolyte's burning. And as we said earlier, when we train the fire departments, and this is also, this is the Tesla recommendation, and we've done a lot of studies on this, and we've tested it. The container itself is actually designed to burn, as opposed to like a house or a car isn't built to burn. This is designed to burn itself out. We call it self-consuming. So when I come up and do the training of the fire department, that's kind of the main, it's very extensive training, but kind of the main takeaway is don't put water on it. Let it consume itself, and the problem essentially goes away. And the smoke is essentially going to be the same. Yes.
What happens if somebody came and they didn't know when they started adding water?
So
or say you were in a torrential downpour and it was raining for a day. Like what
the main
happens?
problem with trying to extinguish it with water, and that's the only medium that we use on battery fires is water. We don't use foam. We don't use anything else. Water is the best thing. So you can put a whole bunch of water on it, and you might knock down the fire. But the problem you're going to have now is there's going to be a whole bunch of cells in there that were heated and that got wet, and now they're all potentially going to burn. And you just extended your event from a couple hours to it could be weeks. So we say don't, because now we have to remove all these cells. But if you let the thing burn itself off, it kind of solves the problem.
During the destructive testing, was that part of? I don't know if there's.
That's the testing. We don't try to put. We used to try to extinguish it, and then we learned, and industry started designing the containers so you don't put water on it.
Do they use any kind of a suppression system? Okay, they're saying don't use water, but there's no suppression system as a last fail-safe. I mean, yes, we've got all this technology, we could shut it down, blah blah blah, but there's no suppression for it.
No, because and the industry was trying that, like different aerosols. The problem they were having was the release of the aerosol was causing more problems than solving because it was damaging cells that weren't involved.
That's the ticket. Yeah.
So the technology is, in my opinion, it's pretty matured.
Is one brief question. I know you mentioned NFPA 855. The version that we're talking about is 23 version.
23.
Is there any? They're coming out with the 26. As a matter of fact, I think they came out with it already.
Yeah.
Is there any significant difference that you're aware of between the regulations and the 23 version as opposed to the 26?
I don't know.
You don't know?
I don't know. No.
Only because of the fact I know the building code is going to be is essentially out, and I'm sure it references the 23 version. Although, like I said, the 26 version
Yeah, I haven't seen a 26 version, but I know it's supposed to
Yeah,
either
it's
come out. I don't know if it came out.
It's out.
It's out. Okay.
It's out, and I'm just wondering whether or not there's anything significant in that regulation that basically.
I'm sure there is, but one thing that I think is more applicable in New York State, we had an interagency working group that worked with the governor's office, and we updated the state fire code,
Right.
which incorporates all the things I just talked
and
about.
Yeah, no, I understand that. And basically, I guess what I'm saying is that typically when the building code becomes updated, they look towards, as you're probably well aware,
Yep.
the reference standards that they use to essentially, rather than repeating everything that's in a reference standard, they say, look at this.
I'm sure that's what New York State's going to do.
And I'm sure they didn't go to the 23, to the 26 because it just came out.
Yeah.
You know, there was as we both know, a rather lengthy process to get to a new edition of the building code.
Yeah, I stopped going to meetings because they were.
Yeah, I know.
very
It's,
repetitive.
it's very repetitive sometimes. I've been to several myself. And I'm just wondering whether or not there's any significant change, because at the end of the day, I'm sure a couple of years from now, you know, the state's going to adopt whatever is the new standard.
Right.
And at least in considering this particular application, is there anything that we could or should use in the 26 version that isn't part of the building code right now?
If I can just address that.
Yeah.
I think it's a point well taken. Quite frankly, I think all of the comments, conditions, issues related to whether it be the new New York State Building Code or NFPA 855, these are all issues that can certainly be addressed and would be addressed with the entity agency that has jurisdiction over that, which would be the building department. So as of right now, we are,
Well, the
I'd
building.
say, a ways from there.
Yeah, no,
And
the
if there was a condition of approval that specifically called out the fact that the facility must comply with whatever the applicable regulation is at the building department stage for fire and
Well, the building
building
department
code.
stages would be, if it lasted for
Correct.
the next 2 years, would be the 23 version.
I'm sure there could be a condition that would address that type of issue. So that the way the building department's aware of it, not that they wouldn't be, but that's where the jurisdiction, I think, would
Bill,
lie.
do you expect a radical difference between the 26th
I
and
don't
the
know.
23rd?
Yeah.
I don't know.
Just to add to that, the manufacturers comply with the NFPA 855.
Yeah.
So by the time, you know, the battery we're talking about here hasn't been built yet.
Yeah.
So when it's built, it'll be built under that.
Well, yeah,
you know.
I guess the reason I'm asking is that typically, again, if we're talking about a time frame, and this has really nothing to do with the variance application that we're talking about, but we're talking about basically something else entirely, which is the standard under which the physical plant is going to be constructed. Typically with the building code, you know, as you're aware, the last version of the building code was in 21, I believe. It hasn't changed since then.
I think 20.
20. So there's a gap, and it's always been that way. And
Well, I think that's a point well taken. And, you know, as we said with the new fire code, we, from day one of design to the new fire code, even before it was adopted, just based on the recommendations. So things like the fire detection system,
Yeah.
which we volunteered, the hazard mitigation analysis, which we submitted almost a year ago, the agreement to do the fire department planning and training, which we submitted many, many months ago, the third-party safety inspections, which we committed to. So we were already ahead of all of that and will continue to be. I think what's important, there was some statements that I think from a legal standpoint were incorrect regarding the public utility standard, and I certainly want to address those. First and foremost, this is very important. The courts have been very clear about that zoning relates to a use and not the user. And there were statements that somehow Rick Energy was not a public utility. Not only is that irrelevant, it's incorrect in this context. And I'll give you the example. Why is Con Edison a public utility? they're a publicly traded corporation. Okay? They're a for-profit entity. Okay? Just as is Verizon Wireless or T-Mobile. And the Court of Appeals, New York State's highest court in 1997, and expanded Con Ed v. Hoffman and Cell 1 v. Rosenberg to wireless service as a public utility for zoning purposes. Okay, so whether Rick Energy or the property owner, whether the property owner is a private individual or Rick Energy is a company, is irrelevant to the applicability of the public utility standard. The courts have been very clear about this. In fact, we cited extensively in my memo of law to the Freepoint Solar case, which went up to the appellate division in the third department. And the Freepoint Solar case specifically mentioned this fact, that the solar company was also entitled to the public utility standard because they're providing a public utility service. In that case, electricity, the same as here. That was also the same finding in White Plains. This is nothing unusual. So the statement that somehow the applicant's not a public utility is completely wrong under the applicable case law and the standards. We've talked about this a lot. I put it in my memo. We submitted a number of documents to demonstrate the need. We submitted the storage hosting capacity map by Con Edison, detailing that the Con Edison provided network level storage hosting capacity values are applicable for the integration based on the proximity of this facility. We submitted the CSER study, and the CSER stands for the report that Con Edison prepared to confirm that this facility could be integrated and interconnected into the Con Ed grid. We submitted that study. From that study, because of those findings, we also submitted the redacted copy of the actual interconnection agreement between RIC and Con Edison for the interconnection of this facility into the grid. And we've established all of that. We've also detailed and cited to, and I think we submitted the NYSERDA June 2024 press release, but cited to the actual order. The PSC and the state legislature, going back over a decade, has been looking at the issue of renewable energy and updating the grid. And we've talked about this a lot. And in 2024, in June in particular, the PSC issued an order specifically focused on battery energy storage, the need for it, and the need for it to meet the state's goals under the Climate Act for renewable energy and to reinforce the grid. In fact, the county Department of Planning specifically noted this in their recommendation letter, where they recommended the approval of this use variance, and in prior letters where the county recommended against the code change prohibiting these types of facilities. The county's quote was, in fact, they said it was crucial, being battery energy storage, quote, crucial to the continuation of service. That's what the county said about this. So if you look at the PSC order from June 2024, it talks about the need for battery energy storage systems throughout the state for the grid, for purposes of the grid, and the electrification of the grid. The Freepoint Solar case talks about exactly this. They talk about that the need has been established because of what the PSC has said about renewable energy and the need to incorporate it into the grid. So I think we've established on a macro level the need, but I think we also have established quite clearly the micro level need based on this particular facility at this particular site with the interconnection agreement, the CSER study, and the Con Ed hosting map. These were the same types of documents that the White Plains Zoning Board relied on in finding the applicability of the use variance standard in White Plains that we submitted to you. There's also a lot of this language out of Tarrytown when they approved that facility. And again, I remind the board that there is a facility in the town that was previously adopted on Gomer Court. I think the statement before, again, was a little bit misleading. There's a house on that property. There's a residence on that property on Gomer Court. There's another house right behind it, and their house is right across Route 6. And it was originally in the floodplain, and there was a LOMA change to the floodplain map, and it's right next to, I want to say, Mohansic Lake. And that facility was studied by the planning board, and it was designed properly, and it's next to a floodplain and next to a wetland and a lake, and it was ultimately approved because the design by the planning board was ultimately deemed sufficient. And it would be the same situation here. I think that's work for the planning board to do, but I wanted to reiterate the standard under the public utility standard that I think we clearly meet. Just to hit one other point that the chief touched on those 5 incidents out of the numerous facilities throughout the country, there was no contamination or injuries from those 5 facilities. The process of letting them burn out in place worked, and that's how it was designed to work. That's a big difference, and I think we talked about this last time. This is a totally different type of facility than what you hear about Moss Landing, where it was a walk-in facility, a much older style. They're not building those facilities anymore. The technology has changed. We're using the most modern technology. There's a big difference. This is not 114 megawatts like was proposed in Carmel. This is 5 megawatts for community distribution into the local grid. Thank you.
Question for you. As proposed, is this site limited to what you're putting, or can more be put on the site? Can you expand it going down the road? Can we make it bigger, or?
I mean, we don't have any plans to make it bigger. Typically, it's limited to 5 megawatts per facility. Is that correct?
Okay, I mean, I think I asked this question once before.
And I think
but
that was,
I'm getting, senior moments.
That's
I
correct.
forget. But, okay.
If it were the much bigger facility, then it would arguably go through the ORES process at the state and wouldn't be coming here.
Yeah, I'm saying if you're starting it off small, can you expand and get bigger as you go down the road? This way, you're kind of avoiding going through the state if you're proposing a big.
Yeah, no, we're not segmenting any type
All right,
of
very cool.
development like that.
Any other questions from the board? Any other comments from the audience? Okay, that's fine.
just wanted to say that.
You can
have to come to the-
this side.
I just was going to say that trail that we were discussing. It is a marked trail, and it is marked with Town of Yorktown trail markers on it, just to throw that out there if anybody's not familiar
Okay.
with that. So that I think somebody should consider, and then, go from there. And the only other thing I would say, I don't like the comparison to the Gomer Court repeatedly, because have you all been over there to look at it?
I think we were there when it was.
When it first came down? Okay,
yeah.
because if you look at the 2 properties, they're not as similar as being made sense. There's a small creek way down in a gully over there comparatively, and it's not near Lake Osceola. It's got the what is it called? The Sunrise Carpentry yard on one end. It's got the in front. It has the auto body shop, and then there is a house attached onto it's the top of that garage, but it's a commercial site, country commercial zoning, and this being a split zoning and being there's a residence with an in-ground pool right next to it, I just hope that the character of the area is taken into account, as it should always be taken into account when you do a use variance, because the planning board has made these decisions with the whole town in mind. So just, I'll just leave it at that. So thank you.
Thank you.
Thank you.
With all due respect, that's not the standard. Character of the community is not the standard. So the burden on the applicant to prove the need is diminished to the extent that the impact on the community is correspondingly reduced. But there's no community character standard under the use variance standard. Nevertheless, as I mentioned before, the property owner is the one that owns the house on the property that's leasing the space for the facility.
Okay, thank you.
I have another question. And we may have went over this. So these cells are monitored. You have BMS,
Correct.
some system.
Yes, BMS,
remotely.
exactly. Yep.
Is there, and we may have gone over this, is there physical maintenance or preventative maintenance, or does somebody physically have to come there to make sure that something is?
There are routine inspections, of course, yes, and a routine inspection process.
And I just have a question, because I'm not an attorney. If there became an issue with the property owner and Rick Energy, and the owner did not want to allow access to the property, what would the means? How long could that go on? And
Well, it
that
could.
you guys wouldn't be able to access the property because the owner.
It would take as long as it would take me to get to Westchester Supreme Court to get an injunction, quite frankly.
Right.
I don't mean to be flip about it, but we have a binding lease agreement that provides 24/7 access, full access easements, and that's a very important thing. And I'm fairly confident that a Supreme Court justice would say yes, you immediately have access. But we don't envision that. I mean, the property owner's been here before. I mean, like, there's been no. They've been a pleasure to deal with.
You just stop the check.
And we would stop the check, of course.
The easy part.
With that, we'd ask for the public hearing to be closed. We understand you probably need to deliberate and
Yeah,
speak
so
with
we're
counsel.
basic plan would be to close and reserve at this point.
Thank you.
The one issue I have is these pictures. I'd like them in the record, so I think I'm okay to just make a statement that we'll put these pictures in the record, but we're going to make a copy and return the originals to who owns them. Is that okay?
And if you can close, could you just also leave open for 10 days after we receive a copy of those to respond to the extent we need
Yeah,
to? I just
okay.
haven't seen them. If we could just have that, so that way, if we do
fact,
have a response to them, that we have an opportunity inside the record.
So we'll do
It'd be
that.
interesting
Thank you.
to see what that would be.
So
Curious.
I will make a motion to close this hearing and reserve our decision, which gives us a time period of about 59 days to render a decision. And I will leave a 10-day period of, for the public and/or the applicant to submit additional information to the record. Do I have a second?
Second.
All in favor?
Aye.
Aye.
Thank you very much. Have a happy holiday.
Same
We'll,
to you,
we'll
sir.
see you next year. Thank you.
So, so he can either make, now that we have 10 days, you can either make a copy and scan them, or we can do it for you.
Let them do it.
We'll do it.
I just want to make sure.
If you got any more, I mean, we'd be interested, you know. You know, you're out there with the canoe or, you know, the rowboat, you know. Yes. I remember when it did flood, boy, that does get, I never knew how deep it got, but you could see the water out there. Deep.
Okay, thank you everyone for bearing with that hearing. We will now go to public hearings for tonight. Bisagna, this is a renewal, so we'll go to the end.
Who's this? Oh, Pisagna.
Yeah.
Pisagna.
Pulver Miller,
It's a-
it's another renewal, so we'll go back to that one. Carpino. So Carpino, this is an application for a special use permit for a renewal of an accessory apartment under new ownership that requires a special permit at 1145 Glen Road. Can you state your name for the record?
Yes, Ronald Joseph Carpino.
Okay. So we're going to pull the file. I think the issue that we had was we didn't understand the size of the apartment, I guess. It's been there, but there was conflicting information in the record as how big the apartment was.
The size might have been overstated because they didn't exclude mechanics.
Well, I saw one memo one application in the past, I guess the prior owner wrote 1,500, another one said approximately 750, and then we have this.
Yep, I have the solution.
Okay.
So what happened is when I submitted the application, I took the area of the entire ground floor, which included a family room for the main house as well as the accessory apartment. The accessory apartment is around 760 or so square feet.
Okay.
Yeah. That was my fault. Sorry about that.
All right, so as a matter of fact, I talked to you on the phone.
That's correct. Yes, I remember.
Did you measured, huh?
Yes. I went
Okay.
down there and I measured it, and I was like, oh my God, I included the entire ground floor.
Okay.
So,
All right.
Okay, so
We're admiring the boiler. We were admiring that
Some-
boiler. That
some
was
system.
a beautiful
yeah.
setup down there.
that was one of the selling points. The
was-
seller's
that was
like,
pretty
brand new
sharp.
system.
Oof.
All right, so you're going to be living in the upstairs area, and you're going to be renting out the lower level where the accessory apartment is. Is that
Yes, sir.
correct?
That's correct.
so
You are the new owner, basically.
Yes.
You've been in the premises for how long?
Yeah, we have, we closed on the 24th of October, but we've been living there for about 2 weeks,
Okay.
maybe 3 weeks.
All right. Well, welcome to the neighborhood.
Yeah, I'm pumped. Kids are already in the school district.
Good.
So the only other thing that there was a third bedroom, but in reviewing the past records, this was legalized a long time ago, and it was a pre-existing apartment, and the original accessory apartment law allowed the zoning board flexibility in, granting the special permits of pre-existing apartments. That was the whole goal of the original law, was to kind of legalize a lot of mother-daughter homes and whatnot. So this basically meets all the standards of the point in time, and as of today.
We have a memo from the building department.
Yep. So I have a memo here from Steve Frayetta dated December 8th, 2025. This is an application for renewal of a special permit for an accessory apartment per 338 of the town zoning code. The property is in the R140 district. I inspected this property on December 8th and found no violations. I have no objections to granting a renewal of the special permit. Okay, so given all that, I'll make a motion to renew the special permit at 1145 Glen Road for a accessory apartment for a period of 3 years. Do I have a second?
Second.
All in favor?
Aye.
Okay. It's granted.
All right, is that it?
That's
That's
it.
it.
All right, well, thank you very much. Have a great night.
Unless you want to come back,
We'll see you in 3 years.
3 years.
3 years.
Put a reminder on your calendar. Okay, Gazzola, 1281 McKeel Street. This is an application for a special use permit for a renewal of a chicken coop that requires a special permit per 300-81 of the zoning code. Okay, will you state your name for the record?
Hi, Lauren Gazzola.
Okay. So do we have a file on this?
Should be here.
Basically, it's a renewal, so
Yes.
you've been there.
Hang on. Let me give you this.
Yeah, we initially did it last year when we moved in.
Who is this
Here's
from?
a
McCoy?
This is where they had the.
Nothing's
they have a
changed,
pool.
no additional chickens, no additional runs, nothing's changed. The only thing we did do was put up a fence recently,
What's
this?
so that will
Is this it?
block even more from the
Gazzola, I'm
from the
sorry.
view.
Yeah, I do remember this one really seems recently. They had the screening in the back and, all of this. So.
The original application was last year, is that correct?
Correct.
And the reason why you're here so early is because the ordinance says 1 year for the first one,
Right.
and then we can do 3 for the next one.
That would be fabulous. That was going to ask if there was a way to make it longer than a year.
When it's,
Yeah,
when it's a first-time venture, you want to see how it works out. Sometimes you as the owner of the chickens decide this ain't for me.
Yeah,
You
it's
know?
not for us,
There
yeah.
was that neighbor on the right that was,
Wasn't there?
That's probably, yeah. No,
You
we
didn't
have
give
no
them-
issues.
You didn't give them enough eggs. That's what happened.
That's right, they come up and say. No, but they're not free range or anything, so they always stay
Yeah,
within the run.
We
and-
saw it.
Yes, yeah, I'm sure you've seen them. They're shedding right now, which is always fun.
Okay, I have a memo here from the building inspector. I'll just read it.
Okay.
Memo from Steve Frayetta, December 8th. This is an application for renewal of a special permit to allow a chicken coop. I've inspected this property and found no violations, no objections to granting the renewal of the special permit. Does anyone in the audience have any comments on this? Okay, given all that, I will make a motion to approve the application for a renewal of the special permit for the keeping of a chicken coop for a period of at 1281 McKeel Street for a period of 3 years. Do I have a second?
Second.
All in favor?
Aye.
Aye.
Okay, 3
Thank you very
years.
much. Thank you. Happy holidays.
Happy holidays, thank you.
McCoy? Okay, this is an application to construct a shed with a side yard of 9 feet where 10 feet is required and a rear yard setback of 8.5 feet where 10 feet is required at 2192 Pondfield Court. Can you state your name for the record?
Michael McCoy.
Okay, so we're gonna pull up our plans here.
Yeah,
Yeah, all right, that's your
Okay.
file.
So is this a pre-existing type shed or your?
No, it's a new shed,
Was
prefabricated
was
shed.
the site, did you previously have something on the site?
There was a gravel pad there, and I put a concrete pad there to house
So I'm
this.
looking at, we were looking at the size and we were out there, it was like, was this
something
It
you
was
ripped?
that platform was there when I bought it, like the just general grading up there.
Yeah, yeah. and
It was
and
gravel.
And what was it, like a patio or what?
Yeah.
Oh, okay.
Yeah.
I mean, we were trying to figure out what was being
Maybe a
used for.
gazebo or something. up
Yeah,
No,
yeah.
no, there was never a structure. Just like a bunch of pavers, basically like a patio. Yeah.
Do you know the square footage of the shed?
It's 24 by 16.
You're gonna make
Was
the
it
man. That's
440?
gonna be the man cave, right?
Maybe some when I can secure the budget. Maybe
Nice wood stove in there. You know,
Yeah.
it's just,
wood stove. I don't know.
We're very
So
large
Maybe a
dog
split.
house.
Yeah.
I assume you've applied for a building permit that size?
Yes.
Yeah. And how high is the shed?
16 and a half feet, Florida peak.
Accessory structure, is that allowed to be that high?
Midpoint of the roof would be under that,
What?
the midpoint.
Midpoint of the roof is under
Under
15?
15, so you should still be
Right.
fine.
think there
Okay.
was some concern maybe with screening in the back or something.
Yes.
Is that-
the house behind you on the hill. Are you gonna screen it? Are you gonna try? Can you screen that a little bit, the back of your shed from their view? Because they're right above you. You look right down into your, whatever it is, your.
Am I going to screen it from them?
Yeah. Can you screen it from them?
Yeah. If you can give me some like record. You mean by screen? What do you mean? Like a?
Plantings.
Plants.
Oh, yeah. I could do that. I hadn't considered it, but if you'd like me
They're
to.
not here. If they're here to
Yeah.
object, I mean that's another
Uh-huh.
position. But
Yeah, let me just ask, is anyone in the audience on this application? Yeah, it's a tough one with the screening if no one,
if they're not here to complain about it, then let
let's
them
say,
let it ride, man.
yeah,
You know?
they didn't see, they read the memos, maybe there's a memo in here from somebody other than Steve.
No, there's no.
No, it's not.
So let me just read this building department memo.
Okay.
From Steve Frayetta, December 8th. The applicant is requesting variances to construct a shed with a side yard setback of 9 feet where 10 feet is required and a rear yard setback of 8.5 feet where 10 feet is required. I've inspected this property on December 8th and found no violations, no objections to granting the relief. Okay, so given all that, it is a rather large shed, but, you know, we do typically, you know, these variances do not seem to be substantial. 9 where 10 is required, 8.5 where 10 is required.
Right.
So, in many cases, our shed variances are 1 foot off the property line and things like that. So, I guess I'm more likely to not require screening, only because
Hey,
you
nobody's
just
here to
never know
complain
what
about-
the screening really even.
and there's nobody here to
Yeah.
complain about it. So I mean, what's the point is moot.
Anybody else have any?
No.
thoughts? Okay. So I will make a motion to approve the application to construct a shed at 2192 Pondfield Court with a side yard setback of 9 feet where 10 feet is required and a rear yard setback of 8.5 feet where 10 feet is required, with the stipulation that the shed be installed in accordance with the plans that have been submitted, and that these variances only pertain to the requested variance and not the remainder of the property line. Do I have a second?
Second.
All in favor?
Aye.
Aye.
Okay, it's granted.
Thanks, folks.
You're welcome. Swain? This is an application to construct an addition that requires a combined yard setback of 12.25 feet, where 40 feet is required per section 300 of the 21 of the Appendix A of the Town Zoning Code. A previous variance for a side yard setback of 8.75 feet, where 15 is required, has been granted. The address is 3481 Alta Drive. So can you state your name for the record, please?
Sure. Stephen Bassini of SJB Architecture. Here representing the owner, Brian Swain, for this application. Just a correction, I think the way you read it, and it's been a little confusing at times, but the variance is for 12.25 square feet. The combined side yard setback is not 12.25.
We were going to make that correction.
Okay, thank you.
Because basically the way the language should be is that the combined side yard of 27.4 as opposed to 12.5.
Correct. The denial letter that I have states it correctly. I think maybe somewhere along there was a language in another letter, but
So what we're going to do is basically change the wording to say that it requires a combined yard setback of 27.75 feet where 40 is required.
correct.
That's what's
It
gonna.
provides
that's-
20 yes,
That's
thank you.
what it's gonna wind up being.
Correct, and we require a 12.25
Yeah, no.
variance, but however it is, yeah, the way you word it, absolutely, yep,
That's
thank
the
you.
way, that's the way
wanna
we're
make sure
going
It's
to
a
do it.
variance for a setback, it's a variance for a combined yard of 27.2, point
We want,
75,
the application and the variance is gonna be for what's really gonna be out there.
Got it.
In
Wh-
terms
what
of
will
the
be
combined
what will be
site.
existing when we're done? I understand. Thank you. I appreciate it. Or what we're proposing to be done.
Yes.
So yes, thank you. So
That actually makes me feel better that you clarified that, because I thought we were much more substantial.
going from 40 down to 12.25, right? Exactly. Yeah, that's when you said it. It sounded alarming to me too. If I may explain, essentially, as you have the application, the drawings are there. The request is to build to remove a 314 square foot deck in the back, build a single story structure just to expand the living area. This is a true split level ranch, so you really have your habitable living area on one level with your bedrooms upstairs and your kind of playroom in the basement. So we're looking to expand just for entertaining as the family grows, a little bit bigger kitchen, bigger dining area. So taking over the existing deck in the back, running along the north side of the building there, the exact same profile, a single story. In the elevations you can see as we've designed it with a reverse gable going out the back, it lends itself to the roof actually tapering away from the neighbor's property. So really the impact is is very minimal. It's a single story. It is in line again with the shed, with the existing deck rather. It goes out 2 feet further than what is there, but ultimately because the north side of the house and the north property line are almost parallel, they are slightly skewed off. Really, we're only looking at about a foot more than what is there now as far as a side yard setback. So there's 19.9, I believe, right now. We're requesting 19. In fact, there's a few inches there to make it 19. It's less than 19. I'm sorry, it's greater than 19, but I never like, with siding and survey measurements and everything, I like to make sure we've got a few extra inches so the as-bills don't mess us up. I don't believe I've addressed the 5 comments from the state law, town law rather. I don't believe there's any impact to the neighborhood environment. It's not substantial, especially now that we've corrected the language. And honestly, it faces the garage of the neighboring property. I believe you were out there this last weekend. It faces the garage. There's a substantial separation between them, and there's even a shed on that side of the property. So I know the owners, just the way it's set up in the back, they are entertaining, or whatever their patio is on the opposite side of the property. So there really, I don't believe there's any impact to anyone.
So,
That's-
I guess
yes.
the only question one of the questions I have is the nonconformity is already there if you're going kind of L-shaped backwards, right? Like, are you increasing it or?
We are increasing only because we're going 2 feet further.
Towards the back.
So, towards the back, but because the property is skewed,
Yeah.
the north side of the building and the property line north are slightly off parallel.
Okay.
So it doesn't run perfect there, which is why there's an increase.
Yeah.
And in fact, like I said, it is not truly the 0.92 feet that's there. I increased it a few inches because I don't like to make errors once the survey comes out.
Okay. We have
I
a
guess we
memo.
didn't flag the first time. I think there was a combined side yard that might have been required when they went for the 8.75, but I guess that doesn't matter. Okay, so I have a memo from our building inspector, Steve Frietta. This application for a building permit to construct an addition that requires a combined yard a setback variance of 12.5 feet, and that is true, where 40 feet is required per section 300-21 of the zoning code. I've inspected this property on December 8th and found no violations, no objections to granting the relief. Okay, any comments from the public?
You got the file.
Oh, sorry. Any comments from the board?
Nope.
All right, so I will make a motion to grant the variance for a combined side yard of 27.75 feet, where 40 feet is required at 3481 Alta Drive, with the stipulation that this applies only to the requested variance, not the remainder of the property line, and that the construction be executed in substantial conformity to the plans that were submitted. Do I have a second?
Second.
All in favor?
Aye.
Okay, it's granted.
Thanks very much. Happy holidays, everyone.
Thank you. Bolfamonte? Okay, this is an application to legalize a previously built deck that requires a side yard setback of 8.2 feet, where 10 feet is required per section 321 of the town zoning code at 3298 Poplar Street. Can you just state your name for the record?
John Belfamonte.
So what do we got?
Just trying to legalize a deck, pre-existing deck, when we bought the property 2 years ago. Just trying to bring it up to code, and the former owners didn't do it properly. It's back left corner. Just trying to seek a variance for it.
Are you gonna redo the deck, or are you just looking to just?
Nah,
describe
we
it?
just want to bring it up to code. The steps got to be redone. I have 3 little kids.
Sure.
So I just want to make it safe for them. So I'm just trying to do it properly.
So did you pull a permit for that work, or how?
Yeah, we did.
Is that how you found out?
So you guys
She
flagged it?
she kind of told us about it, but she tried to do it correctly, and it wasn't correct. So we're just trying to make it proper.
Okay, well, I have a memo from Steve Frayetta. Application to build, for a building permit to legalize a previously built deck with a side yard of side yard setback of 8 feet 2 inches, where 10 feet is required.
8.2 feet.
Yeah.
The memo says 8
the
feet
wording,
2 inches, but
Yeah, this says, yeah, the
what does the plan say?
8 feet to
8.2 feet. All right, well, his memo says 8 feet 2 inches, but
Really?
it's actually,
My apologies.
it's okay.
It's 8.2 feet.
8.2 feet is very different than 8 feet 2 inches. We should adopt a
About
metric
another inch.
system, and then it wouldn't be a problem. Okay.
It's about another inch.
Has inspected the property on December 5th. No apparent violations, no objections to granting the relief. Any comments from the public? Any comments from the board? Okay, I will make a motion to grant the application to legalize a deck that requires a side yard setback of 8.2 feet, where 10 feet is required at 3298 Poplar Street, with the stipulation that this applies only to the requested variance, not the remainder of the property line, and that the deck be built in substantial conformity to the plans that have been submitted. Do I have a second?
Second.
All in favor?
Aye.
Okay, it's granted.
Thank you.
You're welcome.
Have a good night. Thank you.
Good night.
Okay, so we'll circle back to a few renewals.
Give me that. Ms. Bisagno.
Okay, so, do you want to read the memo? So Bisagna, not here, is an application to, let me go back to page 1. Application for a special use permit renewal of an accessory apartment at 586 Madison Court. Memo from building, application is December 8th. Application for the renewal of the special permit in the R120 zone. I've inspected this property, found no violations, no objections to granting the renewal for the special permit. I'll make a motion to grant the special permit for an accessory apartment at 586 Madison Court for a period of 3 years. Do I have a second?
Second.
All in favor?
Aye.
Okay. Pulver Miller. Okay, Pulver Miller is a renewal for accessory apartment at 2624 Windmill Court. I have a memo from the building department This is an application for renewal of the special permit for an accessory apartment. I've inspected this property on December 8th, found no violations, no objections to granting the renewal. Okay, I will make a motion to grant this application to renew the special permit at 2624 Windmill Drive for a period, the special permit for an accessory apartment for a period of 3 years. Do I have a second?
Second.
All in favor?
Aye.
That's approved. That's everything, right?
I believe so.
Okay, this concludes our meeting for tonight. We will see everyone in January. Happy holidays and happy zoning.